When it comes to medical malpractice cases, one of the most important aspects of building a strong case is the use of medical experts. These cases are often complicated, filled with medical terminology, scientific details, and specialized procedures that most people, including judges and juries, simply don't have the expertise to fully understand. This is where medical experts come into play. They serve as guides, translating the complexities of medicine into clear explanations that can determine whether malpractice has occurred. In this video, we are going to explore how medical experts are used in malpractice cases, why their testimony is so crucial, and what role they play in helping both plaintiffs and defendants make their case. Let's begin with the foundation, establishing the standard of care. In every malpractice case, one of the first questions asked is, what should a competent healthcare provider have done under the circumstances? This is where the expert steps in. A medical expert, typically someone practicing in the same specialty as the doctor being sued, testifies about the standard of care. For example, if the case involves a surgeon, then a surgeon with relevant experience is often brought in. They explain to the court what a reasonably skilled and careful doctor in that field would have done in the same situation. Without this testimony, it's almost impossible for a jury to know whether a doctor's actions were appropriate or fell short. Once the standard of care is explained, the next step is determining whether the healthcare provider actually breached that standard. This is essentially asking whether the provider acted negligently. To answer this, medical experts carefully review the patient's records, test results, hospital notes, and treatment history. They then compare what was done to what should have been done. For instance, if a patient had classic symptoms of a heart attack, but the doctor failed to order an EKG, an expert might testify that this was a breach of the standard of care. The goal is to identify whether the doctor's actions, or failure to act, represent negligence. But proving negligence alone is not enough to win a malpractice case. The law also requires proof of causation, which means showing that the doctor's mistake actually caused the patient's harm. This is another area where medical experts play a critical role. They help the court understand whether the patient's injury or worsening condition was the direct result of the negligence, or whether it was something that could have happened anyway. For example, if a cancer diagnosis was delayed, an expert may testify about whether that delay significantly reduced the patient's chances of survival. Without expert input, it can be extremely difficult to separate unavoidable outcomes from mistakes that caused real harm. In addition to causation, medical experts are often called to testify about damages. Damages refer to the harm suffered by the patient, both medically and financially. An expert might explain the extent of the injury, the long-term consequences, and the type of care the patient will need in the future. For instance, if malpractice caused a permanent disability, the expert can provide detailed insight into what kind of medical care, therapy, or assistance the patient will require for the rest of their life. This testimony is important because it helps the jury understand not only what went wrong, but also the impact it will have on the patient going forward. Ultimately, this shapes the financial compensation awarded to the victim. Another important function of medical experts is providing objective insight in a case that is often emotional. Malpractice lawsuits can involve heartbreaking stories, patients who suffer lifelong disabilities, families who lose loved ones, or children whose lives are forever altered. In such emotional situations, jurors may feel swayed by sympathy. While compassion is natural, the court must focus on facts and evidence. Experts provide a neutral, scientific perspective that balances the emotions in the courtroom. Their role is to explain, in clear and unbiased terms, what happened and why. This allows the jury to make an informed decision based on evidence rather than emotion alone. It's also important to note that medical experts are not just used by plaintiffs, the people bringing the lawsuit. Defense attorneys also rely heavily on experts. A plaintiff's expert might argue that a doctor was negligent, while the defense's expert may argue the opposite. For example, the defense expert might say that even though a complication occurred, the doctor's actions were within the acceptable standard of care. Or they might argue that the patient's outcome was caused by an underlying medical condition rather than the doctor's mistake. In this way, both sides use experts to support their arguments, and the jury must weigh which testimony is more credible and persuasive. In many states, the involvement of a medical expert is not optional, but required before a malpractice case can even begin. Some states have laws that require a plaintiff to submit an affidavit or certificate of merit signed by a qualified medical expert. This affidavit confirms that, in the expert's professional opinion, there is evidence of negligence. The purpose of this requirement is to prevent frivolous lawsuits from clogging up the court system. It ensures that only cases with legitimate claims of malpractice move forward. Without this initial expert opinion, the case may be dismissed before it even reaches trial. Beyond testimony, medical experts may also assist lawyers during the preparation of a case. They can help attorneys understand complex medical records, identify key evidence, and anticipate what the opposing side's experts might argue. In some cases, medical experts even assist in depositions, helping lawyers ask the right questions and challenge the credibility of other experts. Their role is not limited to the courtroom. They are often involved from the earliest stages of investigation until the very end of the trial. The credibility of a medical expert can make or break a malpractice case. Jurors pay close attention not just to what the expert says, but also how they say it. An expert who explains concepts clearly, avoids overly technical jargon, and comes across as trustworthy is far more persuasive than one who seems defensive, confusing, or biased. Attorneys often spend significant time selecting the right expert, ensuring that their testimony will resonate with the jury. In fact, some trials have been decided largely on which expert the jury believed more. So why are medical experts so essential in malpractice cases? The answer is simple. They bridge the gap between medicine and law. Most jurors have no medical training, and even judges may struggle with technical details. Without experts, juries would be left guessing whether a doctor's actions were acceptable or negligent. Medical experts bring clarity, providing the knowledge needed to reach a fair verdict. To sum up, medical experts serve several crucial roles in malpractice cases. They establish the standard of care, determine whether it was breached, explain causation, assess damages, and provide objective insights. They are used by both sides of a case and are often required before a lawsuit can even proceed. Their testimony not only educates the court, but also ensures that the legal system can fairly judge complex medical issues. Medical malpractice cases are some of the most challenging lawsuits to pursue or defend, but with the guidance of skilled medical experts, the truth has a much better chance of being uncovered. Their role is indispensable, ensuring that justice is based on sound science and clear evidence, rather than speculation or emotion. And that is how medical experts are used in malpractice cases.